That just reached us says the Supreme Court has affirmed the election of Ademola Adeleke as the governor of Osun State. Delivering the judgment on Tuesday, a 5-member panel of the Apex Court held that the Court of Appeal correctly reinstated Adeleke as governor. And joining us now from our Abuja studios is Dr. Sam Amadi to discuss this latest development and other situations as well. Thank you so much for joining us on Newsday this afternoon.
Thank you.
So what do you make of this final judgment from the Supreme Court that just came in?
I think it makes for interesting reading or listening, because first, this same Supreme Court affirmed the ouster of or removed, denied Adeleke the governorship previously, and now this Supreme Court has affirmed his governorship. Again, starting from the tribunal, the issue was that the 2 out of the 3 tribunal members decided that there was over-voting, nullified the areas, and therefore, after recalculation, he lost to the APC. And the argument was that the evidence, the Beavers report came in segments, as it were, and at that point, the Beavers report presented by APC showed that accredited voters were less than the total number of scores in the affected area where Adeleke won. And when that court, the tribunal accepted that argument and recalculated the valid votes now, he lost. But our appeal courts did not accept that reasoning. And again, the issue here was that the same tribunal had ordered that they do a comprehensive report, and the comprehensive report shows that actually the total number of votes are tied with the Beavers, with the results declared. What the court of appeal did was to restate it, accepting the minority member of the tribunal's view, and gave him judgment, which now got to the Supreme Court. And the Supreme Court says, look, the final report for everything over voting is the Beavers report, and the Beavers report shows clearly that the votes were valid, the result declared by INEC were valid, and therefore restate his election and affirm the decision of the Court of Appeal.
Well, Dr. Amadi, so what message would you say this ruling sends to Nigerians about the court's ability and neutrality to resolve the 2023 presidential election dispute? Does this give you hope that indeed justice can be served?
Yes, it does. I mean, actually the courts have the capacity, the institutional protection to give judgment and give justice, because essentially courts are not going to be blown away. You know, they are not subject to, until their tenure expires. The judges are not subject to reappointments. They are not subject to removal, except for cause. And the Constitution defines it very clear. It must be for a misconduct that has gone through due process with NJC. So the independence of the judiciary, there have been many scholarly work on that. And people say it's because of the structure of relationship between the executive and the legislature that gives it independence. Other scholars think around the attitude of the judges. So they argue that the judiciary is structurally dependent because it hasn't got the arms, it relies on the laws made by the legislature, it relies on the execution of those judgments by the executive, so it's structurally dependent. But what makes them independent is actually the judges themselves, their decision-making power. They are not bound to agree with you, affirm you. So the fact of the judge himself being somebody who panders to logic, to precedent, if you're not Supreme Court, and then to arguments and facts, give them the decisional independence to choose whatever they want to choose. So it left for you, the executive branch of government, to execute. So the judges are more like priests. They go there, decide a matter, one way or the other, as they feel they should, and then they walk away. So, and then you are morally bound and constitutionally bound to obey. So I think, yes, that's hope that the judges can rise up to this challenge. But the point is that they are also structurally embedded. And so when there is a lot of social crisis, their functionality, when maybe society is corrupt, people begin to doubt whether if the stakes are too high, especially in presidential election, especially when, and that's why many people think that maybe we should be like the US people, foreclose certified result finally before people get to power. Now, in the case of governors, we've seen many governors removed from power. We've not seen any president removed from power. People make false equivalence. You see, no governor has control of the coercive force of state. When Mekeda was removed in 2000, we're all there. It was very easy. I mean, he just had to write and leave office because the next day, the IG could withdraw his orderly. The commander, he's not a commander-in-chief. So the stakes get higher with presidential elections. And one can argue that in 2007, we came very close to, removal of a sitting president when, in the case of Buhari and the Yar'Adua, and it was 4-3. People argue that it was actually the other way around, and the last minute, one of the justices flipped. So we came close to an ouster of a sitting president by a Supreme Court, but we never had that. And so, yes, the court, we can trust the courts based on the process, the logic of judicial reasoning, and of course, the institutional protections they have in terms of tenure and so on and so forth, and the social deference we give to them. We can trust that the judges should, rise up and rise above the structure, the corrupt criminal structures of society. Oftentimes, depending on different society, some societies at some time, criminality becomes high, special interest captures institutions of state. But above all, beyond those, judges have the training, the tools to rise above those dependencies and be independent and do the right thing, but not always easy, depending on the stake and the structure of society.
Okay, what does this mean for Osun State as it is, and especially for the former governor, Ademola Adeleke, as we do know that it's reached the apex court, there will be no appealing. Politically speaking, what does this mean for him?
First, he has to accept that he has fought a good fight and lost. I mean, this is the final court. We expect another action. And then he should be thinking around his political future. I mean, as a governor, one-time governor, could have been 2 times, he didn't get it. Depending on if the APC government holds true with the tribunal, he has got an uncle or a nephew or something who is now a president. So there could be a lot of formal and informal role to play. He could have a comeback. He will now lead the official opposition in Osun State, and his job could be basically rebuild and keep the family going and hope that the governor, Adeleke, sleeps, and in the next election, probably they can overhaul him and he gets back to power, or he could move to other. But for Adeleke, this is an imprimatur, kind of an endorsement that he should go ahead, and now he has no more contingencies in terms of tenure to grapple with, and no anxiety in terms of whether he'll be governor or not governor. He has got a 4 years, but for impeachment, if that ever happens. So he has not got more like, the door has been open for him to exercise his gubernatorial powers and secure for himself maybe a second term or even a name in history as a governor who performed. So he has got one major sort of Damako removed from him so that he can focus on the job.
Now, a number of Nigerians have expressed dissatisfaction with our electoral processes. The fact that most times it usually ends up at the tribunal, at the law courts. What do you think can be done, to strengthen our electoral process so that we don't have to resort to the courts at all times, to resolve this dispute?
Well, the judicialization of election, the fact that elections are determined now by court, and Supreme Court for that matter, is a culmination of many 4 steps. First, we used to have the governorship cases under the Court of Appeal, and of course, by legislative amendment, they're now going to the Supreme Court. Before now, they ended the Court of Appeal, which probably is the right thing to do. Again, we have put up incentive structure that encourage litigation for every electoral issues. And the reason is very obvious. One is that the Electoral Management Body, INEC, has been doing a terrible job of exercising regulatory power. I've been shouting like a broken record that INEC is dropping the ball. First, think around issues that are in court now around whether the vice president of APC was qualified or not qualified by virtue of alleged double nomination. Think around some of the cases that the Supreme Court actually is going to sit on that case maybe on Thursday to decide whether he's qualified to be a vice presidential candidate. This is something that INEC could have dealt with at the level of regulatory oversight. So INEC receives nomination. If the law says it can have double nomination, INEC could observe that there is a double nomination and disqualify. INEC has left such many work it should have done. Think around some of the disputes we are seeing now. We have about 700 and something cases already filed before the tribunal. The all-time high than any other time in our electoral history. Why? Because we saw very many wanton, reckless, abuse of procedure. So if INEC had taken seriously its responsibility, you would have reduced the disposition to go to court. Again, the second thing that will deal with it is if courts really come down, or tribunals come down heavy on electoral malpractice of all sorts, and re-establish that they're going to be zero tolerance for violation of procedure, our jurisprudence of, say, prove substantial, non-compliance is actually a sorry one. I mean, substantial as what was the metric. If there is serious non-compliance, election should be voided. Now, what that does is it resets incentive so that both the INEC and politicians know that if I spend so much, if I violate the law, if I go through this nonsense and win an election that's going to be cancelled at the tribunal, why should I do that? So electoral misbehavior is a cost-benefit analysis. If everybody knows that, look, the court is zero tolerance for errors, for violation of procedure, then people will be more meticulous. People will stop short of violating the law. But because it's like we are giving those who challenge elections, we're asking them to mold bricks without straw. You have to prove substantial non-compliance. So even if we say, oh yeah, this was not followed, this was not followed. For example, if you did an election without beavers as the law prescribed, we're going to nullify the election. That result from that polling unit. If you didn't upload to the IRF or multiple cancellations, we're going to nullify. Those kind of judicial direction will reset the outcome, and so people will now internalize that cost and say, look, you know what? We'll make sure we're not going to be cancelling results and then say go to court and prove it. Because if you go there, they will be damned. So I think that the judicial outcomes have favored electoral malpractices and have encouraged them, and therefore has created multiple cases of violations, and then the court gets overwhelmed. But if we begin to see very punitive actions against malpractices, and then INEC begins to exercise regulatory power. For example, the Act says it can review elections 7 days. If INEC had, after these elections, sat back and reviewed them, made corrections, clarify some of those things. In fact, some of the results, especially at the down ballot, governorship and House of Assembly, you saw very obvious cases of patent errors, mistakes, fraud that the regulator, INEC, could have sorted out before declaration. If they'd done that, you will see less case go to the court. So I think at two levels, at the level of election management, we need to do a better job. We need to have a much more transparent, and the idea of beavers and electoral transmission in this act was to ensure real time. So if I knew that, look, these results are real time, then I will have less incentive to alter things, and then the other guys have no reason to go to the tribunal, because the results, the Electoral Act says the result on the IRF overwhelms, overrides the result, the hard copy result. So there are those structural, processes create different incentives that politicians respond to. It's actually a waste of time begging politicians to have good attitude, good value, be great sportsmen. No, the reason why footballers are good sportsmen is that the referee is always making the call. So why do you have to, you can't go and heckle your opponent. You can't go and tackle him unfairly because you're going to get a red card or a yellow card. So when we begin to re-emphasize the rules and make them punitive and biting, then you're going to see less infraction and then you will see less people go to the court because no point. You're going to spend the money, pay lawyers, pay SN, and you get zero. And of course, if we reduce judicial corruption, so people know we're not going to buy the judges. We won't buy them. And so why spend money? We are going to lose. They won't go to court. Some people know they have a bad case, but they're just this notion that we can actually buy our way. Then, real-time transmission of electoral tribunals, those help. People see through. Everybody knows they're under watch. Like Lord Dennis said, it says the biggest safety is publicity. Make it open. Let people know that they're being watched. That is actually incentive structure for good judicial behavior and good behavior from lawyers who are attorneys appearing before these courts or these tribunals. So I think we need to smartly create the incentive structure around our elections, and you begin to see these cases drop. You begin to see people go to elections, lose, and just go home because everybody knows there's going to be a waste of time going to court because the judges and the tribunals have clear judicial direction on zero tolerance for cancellations, for mutilations, for failure to upload to electronic database, zero tolerance. Then people will stop this criminality and fraud, and then you begin to see less cases go to court. Maybe once in a while, we may have a real challenge, a real problem of interpreting the rules. Unimagined, unprepared, we know something just happened. We said, you know what, like in the US, Gore, Bush, you go to Supreme Court. But all the rest, people just, elections are declared, people just go home because there's really nothing to go and litigate about.
Dr. Sam Amadi, always great to have you on the program with us. Thank you for that analysis and thank you for